Americans love the Declaration, rightly so, but American legal practice doesn't reflect and doesn't represent that same utilization of the Declaration, other than as a statement of political principle, not a statement of legal principle. Americans since about the 1820s have robustly debated the role of the Declaration of Independence in the political sphere and in the legal sphere, and the current debates that law professors engage in scholarship and in public debates is nothing new. And it's important that we as Americans and we as law professors get that relationship right, because there's a lot at stake. The Declaration has phrases like all men are created equal, and different people interpret that phrase differently, but regardless of how one interprets it, if the Constitution in some form or facet embodies that phrase, then that authorizes a different meaning for the Constitution with different implications. The strongest points of contention in the debate among legal academics over the relationship between the Declaration and the Constitution is, first, does the Declaration have a unique role or a unique status in constitutional interpretation? And then second, what that unique role or status is. The Constitution's own text identifies it and only it as the supreme law of the land. And it's inconsistent with that claim of the Constitution's text to say that the Declaration has unique legal status. And this isn't something that scholars in 2018 have thought of. It's actually something that the first Congress in the first session also saw. So the first Congress in the first session, in its 8th law, passed a law reenacting the Northwest Ordinance. The Northwest Ordinance had initially been enacted by the Second Continental Congress under the Articles of Confederation. Since the Northwest Ordinance was not the Constitution, was not a law made pursuant thereto, because it was under the Articles of Confederation, and because it was not a treaty, under the Supremacy Clause of our current Constitution, it became inoperative. And so the first Congress repassed the Northwest Ordinance and expressly said it was doing so that it would continue to operate in the Northwest Territories. Now think about the Declaration. The Declaration was a law passed by the Second Continental Congress. It's not the Constitution, it's not a law passed pursuant thereto, and it's not a treaty. And therefore, just like the Northwest Ordinance, under the Supremacy Clause, for it to continue to have legal status, it would have to be passed again by our current Congress under our current Constitution. But of course, it never was. I think the Declaration and the Constitution have significantly different purposes. First, the Declaration of Independence was primarily about declaring independence of the colonies from the United Kingdom, with a justification both in political principle and in the actual actions of the king. It's relatively theoretical, it's relatively abstract in its justifications, and it's relatively elegant in the language that it uses. The Constitution isn't that. The Constitution is an eminently practical document. The Constitution identifies, for example, how many branches of government we'll have, how long the president's term shall be, what powers will Congress have. It leaves aside the sonorous language of the Declaration and puts in place the practical language of governance. Now, that doesn't mean that they aren't doing something related, and I think, in fact, the Declaration and the Constitution are related because the Declaration identifies the point of independence of the United States, identifies the political principles of the United States, and the Constitution is the mechanism to implement those political principles.